Tonight's symposium, I think, has got very sweet timing. And the reason I say that is because I believe that there is really renewed interest and focus in Australia on the Middle East and Middle Eastern markets and their importance in the context of the world and Australia's place in it. I remember coming on a trip to Australia about 5 or 6 years ago, and I went around and talked to various people in Sydney and Melbourne and said, look, I work for a law firm in the Middle East. Are any of your clients interested in doing some things up there? And the general response I got was, well, why would I want to go to the Middle East when I have to fly over China to get there? Well, times have changed. And one thing that I think a lot of people in Australia will discover, as I did when I first went to Dubai in 2006 and ended up staying there for 13 years practicing law there, was that the Middle East is an absolutely fascinating crossroads between different legal systems. As a legal laboratory, it is really amazing because it is such a fertile mix of the common law meeting the civil code, which is producing a completely different legal model, and that has got very important implications for the legal profession. The particular point that I want to emphasise is that if you want to practice as a lawyer, particularly a business lawyer in the Arabian Gulf, it's impossible to do it unless you've got some common law skills and some civil code skills. You need both. So the people who have been educated, trained and seasoned as civil code lawyers need to know about the common law and need to understand aspects of it. And the people like me who have been trained and practiced in the common law system need to know things about the civil code and the Arabic system, which is basically based on the Egyptian civil code. And the reason that this has happened is because the Middle East has been a focus, and the Arabian Gulf in particular has been a focus of spectacular economic growth in the period since the 1970s, when you had this combination of a massive spike in hydrocarbon production and a massive spike in the prices that those products were attracting, which led to very, very accelerated international business interest in the region, huge inflows of money, a globalised business presence led by big oil, and that has basically stimulated us almost artificially a business model and a business culture that has rapidly developed and has rapidly outgrown and outdeveloped the legal system that was there when all this began. And so the point I'm making is that we should be looking at the Arabian Gulf as a very promising market for Australian trained lawyers, and we should be looking to the Middle East as somewhere where we should be forming linkages and relationships with civil code lawyers who are thirsty for knowledge and training about the common law and particularly the business law aspects of the common law. And both sides need each other. Now, I can illustrate that by telling you some parts of my personal story. When I first arrived in Dubai in 2006, I had practiced law in Australia for a couple of decades, and I said, well, it's time I did something a bit different. So I went and looked around for an international market to practice in, and I got a job in Dubai. So the first question was, after they said they wanted to hire me, I rang them up and said, look, what do I need? Do I need to get admitted in the United Arab Emirates? They said, no, you don't. Just come and work for you. I said, are you sure? Yeah, just come and turn up, we'll pay you. Work. So, and the reason that happened was because of the fact that the way that most of the countries in the region work is that the licence goes with a firm. Just as you get a banking licence, you don't need to be personally admitted as a banker. Then the law firms get a licence to operate as a firm, so you don't need to be personally admitted as a lawyer. That's slightly changed a little bit in Dubai, but just recently, but that was how it was then. So I then found that I arrived in the Middle East, I didn't have to go through any process or any formalities to be admitted as a lawyer, though I had to go through quite a lot of paperwork and formalities to get my alcoholic drinks licence, which also had a high priority. So the way that, and the reason that that I found the market extremely interesting was because I arrived in the Middle East and I said, well, I don't know how I'm going to manage this because I don't speak any Arabic and I don't know anything about the civil code. So how's this going to work? And much to my shock and dismay, all the business documents and the legal agreements that I was shown and I started coming across my email screen all looked exactly like the same sort of agreements, correspondence and documents you'd see if you were practicing in the City of London. And so basically every substantive business transaction was transacted in English and the documents really looked just the same as they would if you were practicing in England. And so now when you got to the courts, that was a different kettle of fish. And obviously the court system was radically different and it was all transacted in Arabic.
That slowed you down.
Well, that's right. But the point was that if you're going to operate a law firm that was sort of wasn't just sort of single, it didn't have a very narrow practice area. You had to have a mix of lawyers who were experts in common law, English style documentation, and you also had to have lawyers that were expert in the civil code and knew exactly what the local law implications of what you were doing were. You can't run a legal practice without both streams of expertise. And that applies on both sides. So what I discovered was that I was actually hired to be the head of the corporate department of Al Tamimi, and I found we had a fairly wide sort of scope of practice with general corporate work and contract documents. And I found that I couldn't run the practice without a blend of lawyers who were trained in the civil code systems, who are perfectly confident in Arabic, and lawyers who were trained in Western systems and could understand common law documentation. You had to have both. And some jobs you'd give to one, some jobs you'd give to the other, some clients were a better fit. Some transactions, a lot of transactions you needed both. Both, you had to have a team that was a composite team of Western trained lawyers and lawyers who were trained in the Arabic system. And the thing that was beginning to happen when I went up there in 2006 in the Arabian Gulf, which was even more interesting, was that historically this situation had arisen because of the fact that the Arabian Gulf countries all used the Egyptian civil code, which was basically rolled out through the 30s and 50s throughout the whole region, and really the legal system is basically pretty similar in most of the Gulf states. There's not much difference. It'd be like the difference between the Australian system and the New Zealand system. There's some fine tuning, but nothing terribly major. But what's happened, of course, is that a lot of the Western business interests, the big global corporations, the British, the Americans have come in, and there's been this demand for the sort of legal products that you get out of the common law system and the type of documents, the types of business deals, the type of transactions, which has been very much reinforced by the fact that if you look at where I was practicing, which is the United Arab Emirates, more than half the population is actually from either India or Pakistan. And they all operate on common law English system as well. And so probably I would say the UAE, I would doubt the majority of the population is fluent in Arabic. And so the lingua franca tends to be English, especially in business dealings. But on the other hand, there's major parts of the legal system that still function, that are very firmly wedded to the Egyptian civil code, Arabic language, and the different concepts they use. So the other thing that's also become interesting, as I said, that's developed when I was there and was gathering steam before that, is that the legal systems in the Arabian Gulf have started actually importing large chunks of the common law system into their own legal systems. Bahrain had a trust law. Had trust law for many years because they thought it would be handy for their banking industry. And just before I arrived in the UAE, they set up the Dubai International Financial Centre Free Zone, which is an area of land of 40 hectares in the middle of Dubai where the law of England applies. And so if you make a contract, if you sign a lease within that 40 hectare area over an office, then that lease will be a common law document, just the same as you'd see in London. If you go across the road, 50 metres across the road, on the other side of the road, that lease will be signed under the civil code. Completely different rule base. And this trend has actually continued. The same sort of system's been adopted in the Qatar Financial Centre. You've got and subsequent to that, Abu Dhabi also adopted their own financial free zone, which operates within a confined geographical area in Abu Dhabi. And in Dubai, if you want to, any contract that's signed in Dubai, you can opt in to the financial centre law, which is the same as English law. So it is simply impossible to separate the practical aspects of practicing from a need to have common law expertise, a need to have civil code expertise. There's a great demand and a great hunger for lawyers trained in the civil code to do what I think the lady in the Cairo node mentioned a bit earlier, to actually go back and do postgraduate work or further qualifications and experience in Australia. And there is likewise a strong demand for common lawyers who are interested in practicing the Legion to actually understand enough about the civil code that they can make a good fist of being a good practical legal advisor in those jurisdictions. The other sort of basic tools that I think are also sort of have accelerated these trends have been the fact that there's been a very strong demand for particular financial products that have got a basis that have been developed in the common law systems. So you'll see a lot of specialised financing products such as securitisation, trust structures of various sort, private equity funds and things like that, which all have been developed in common law jurisdictions and all hinge on things that can't work unless you work them in a common law context. The court system likewise reflects this dichotomy, so that you have cases under the civil code go to the traditional local courts who are all expert in the civil code and who transact in Arabic, whereas actually the free zones that are now set up have actually set up their own courts. And so cases are streamed off in one of two directions and they never meet at the top of the appeal process. It is an absolutely fascinating part of the world to practice law in, a very strong international component, a lot of offshore legal practice that you see there, and it's something that a lot of people in this part of the world should take more of an interest in.